All right, I think we're starting to get everybody in now. Good afternoon. My name again is, you haven't heard me already, my name is John Fisher. I'm with Wayfinders, which is a nonprofit working with a number of housing related issues in the western part of Massachusetts. And I'm going to just go over a few of the basics, and then I'll ask my co-presenter to introduce herself, and we'll get through with this. So first of all, I want everyone to know that we are recording this workshop, so that if you have any problem at any point of having your face caught on a recording or anything of that nature, please be sure to turn off your cameras. One of the reasons we record these where we can and where everyone's comfortable with it is that we do try to make the recordings available within probably about 2 weeks or so after each conference on the conference website, which is www.fhcr.com. And if you go out there under resources, in fact, you'll find some of our earlier presentations. In a couple of weeks, you'll find a recording of this presentation and the slides from it as well. This is something people keep asking us about. So again, anyone who's given permission to record, you will be able to have access to these at some time. The other thing I really want to mention is that we're going to cover a lot of territory today. And we're going to have to run through something like 60 plus slides. And we're doing this in an hour and a half, which works out to something like 1.5 minutes per slide. And each slide has a lot of content to it. So I'm going to ask you to, if you have questions, try to put them in the comments. We will try to get to them at the end of the presentation. But again, it's going to be kind of tight. I do apologize for that. And the other answer I would probably give to most of the questions that I hear in a workshop like this is hang in there, because sooner or later, we're going to probably be answering almost all of your questions as we go along. So we're covering a lot of territory. So I think that's pretty much the ground rules. I'm going to ask Michael, if you just quickly introduce yourself, and then let's have at it.
Sure. My name is Michael Cahill, and I'm a fair housing staff attorney at Community Legal Aid in Worcester. Community Legal Aid is the legal service provider that covers central and western Massachusetts. I'm really excited to be here with you all to talk about the basics of fair housing. My practice includes bringing cases for housing discrimination, requesting reasonable accommodations in housing, and defending against evictions that were brought for discriminatory reasons.
I should probably also add that I am not an attorney. Someone says I play one on television sometimes. But anyway, I'm not an attorney. My particular thing, I work with both tenants and landlords around just information and outreach stuff, trying to make people aware of what their rights are, and directing them to where help may be available when needed. So let's kind of have at it. And let me start out a little bit, and we're really just going to kick this back and forth between ourselves as we go along here. But really, the basic introduction and overview, sort of who's protected by housing discrimination law, what conduct is prohibited, what rights do tenants have, whose conduct is regulated, areas of liability, common issues, and so forth. Now, the other thing I should mention is that we're doing this, our particular areas of expertise have to do with Massachusetts law. And in some ways, Massachusetts law is a very good example for other parts of the country, in that there's both the federal laws, the overarching fair housing laws that cover everybody throughout the country. And Massachusetts also has a fairly robust set of its own fair housing laws. And these tend to work together and complement each other. And while obviously it's going to be a little bit different for each state, I think it's important to get the idea of how these work together. So we're largely using Massachusetts as an example here. Anything else, Michael?
Just that we're just going to be sort of scratching the surface today on some of these issues. We're going to stick to fairly basic concepts.
So you want to just start out with this, because I do get calls from people saying I'm a victim of fair housing treatment, and often they may have a really legitimate claim, but it may not be fair housing.
Yeah, absolutely. So when we talk about what is unlawful discrimination, we have to start with these three separate components. There has to first be an act of a discriminatory act. So for example, like an ad saying no sectioning, an injury or a harm suffered. That would be the person is denied housing opportunity by that practice. And then there has to be a connection to a protected class. So the person has to have an identity that is protected by fair housing law. So in Massachusetts, voucher holders are protected. And so in that example, that would be unlawful discrimination.
And this is really just, again, when you talk about the federal laws, the basic laws, the Federal Fair Housing Act, Title VIII, and some of the other, it's simply race, color, national origin, religion, sex, and actually the feds have become much broader than they used to be in sex. So it really does cover, as far as they're concerned, gender orientation and sexual orientation, gender identity, families, status with children, and again, disability and handicap. You'll see us use these words, or you see the laws will use these words almost interchangeably, depending on whether they're using the older term or the more current term, but it has essentially the same kind of meaning. And then just whoops, somehow we went through one too many here. Give me a second. Yep. Been there, done that. Okay. And so you want just 151B?
Sure. These are the protected classes in Massachusetts. You'll notice that Massachusetts expands the federal, has more covered classes than the federal statutes. And that's really, each state is going to be different. The next couple of slides, we're going to show some of the surrounding states in New England. But really, you have to look up the added protections in your state because it does vary a lot state to state.
Unfortunately, some of the folks we're talking about probably are states where there's very few. But again, as an example, Connecticut is in some ways very analogous to Massachusetts, except sometimes they say things differently. For example, where we have a statute that talks about discrimination based upon having, essentially subsidies. Section 8, for example, which they talk about lawful source of income with much the same purpose. In New York, you have, again, fairly similar types of things. Vermont. But basically, I mean, the thing that you really have to do is when you look at what your state has and what the feds have and put them all together. And really, these are the protections that you have to deal with. And by the way, I might just say, go ahead if you're, too, on the slides if you're feeling.
Go ahead.
Okay, so talking about what violates fair housing laws.
Absolutely. So these are some of the examples of conduct that violates fair housing law. I think refusal to rent or sell is fairly obvious, so denying somebody the housing. Imposing different terms and conditions. So for example, because you have kids, I need a security deposit from you. Yeah. Things like that, something that is different because of the protected class that you're in. Steering is an interesting one. Like, for example, a real estate agent will show only some available apartments to a Black tenant who's like same situated as a white tenant who they show, 10 different apartments to, trying to steer them to a certain location or steer them to a certain landlord. This is absolutely a practice we see real estate agents and housing providers engage in. I think giving false information about whether a unit has already been rented is fairly obvious. Discriminatory statements, we see them very often in ads, saying things like property doesn't accept Section 8, no kids in this building. Things like that are the ones we come across very often. Refusing to grant a reasonable accommodation or modification is disability discrimination. And then I think it's fairly obvious that threatening, coercion, and intimidation can be a retaliatory fair housing violation. A lot of times this can look like clients trying to assert their fair housing rights, like requesting an RA or requesting lead abatement, and then they receive an eviction notice for exercising their fair housing rights.
Yeah, I also, just a couple of side comments here too. One of them is, one of the things I actually take a certain pride in is I've even occasionally seen ads that says Section 8 welcome, but no wayfinders. The implication being that we enforce the requirements on a landlord more strictly than perhaps some other sources of other agencies offering Section 8 vouchers. And you can't do that either.
Yeah.
Also, it's just interesting is that with steering, some of this almost goes back to, if you go back to the 1960s, the early 1960s, the federal government used to have maps where there were areas that were shaded in red, where they would not, essentially not back the writing of mortgages. And so that this was, if you will, a federal mandate. And what it did is the areas were shaded in red, so that's somewhere the sense of where they talked about redlining. And if you look at those old maps and you overlay, if you overlay present day maps of segregation, present day maps of sometimes just poverty, you're going to see that those, if you will, ghettos were actually at least largely created by federal mandate 50, 60 years ago, so that the echoes of this thing is still with us. Yeah, and basically there are reasons that landlords make choices, and but they can't be, they have to be uniformly applied. Everyone should be treated fairly, the same. Can they afford the rent? And sometimes something that we run into here, I believe there's even a workshop on some of this that's being done by some of your associates, Michael, and talking about again, the people with Section 8 vouchers, where somebody will have a rule which says your income has to be such that a third of that the rent is at least a third of or no more than a third of your income. And that's one of those things that seems to be fair on the surface, but if you stop and look at it, the whole point of Section 8 is to make it available to somebody regardless of their income, so that everybody who should not be this subject to discrimination because of their income when they're applying for an apartment. So you really need to look closely at some of these criteria.
Right. Yeah, so absolutely, that's when we see a lot. You have to make 3 times the rent, which is of course discriminatory to folks on government assistance or folks with a disability who may have a voucher that's going to pay their full rent and can absolutely afford the apartment. Then the other measure that for tenant selection that has discriminatory impacts can be focusing on eviction records and criminal records, because we know that Black and Hispanic neighborhoods are over-policed, and result in more criminal records for those prospective tenants, as well as Black and Hispanic folks are evicted at a much higher rate. So while that might seem like a neutral criteria, it actually has discriminatory impacts. You can go to the next slide.
Mhm.
All right, so who must comply with fair housing law? Housing providers, management companies, people who entities that receive federal funding for housing, real estate agents, basically anybody who is a housing provider that is not subject to an exemption, which we will talk about.
Mhm.
So the covered properties in Massachusetts are most dwellings, right, that are not owner occupied. There are exceptions to smaller landlords, especially owner occupied. Massachusetts is more protective. If it's a 2-family home and it's owner occupied, that's really one of the only exemptions. And then if there are 3 apartments or less, then there's an elderly infirm person. Then they can say that they don't want to have children. If children would be a hardship, but they have to prove it. We can go to the next one.
I was just going to say also, sometimes you'll find people who will pick and choose. They'll find, for example, federal has in many cases, a 4-unit exemption, owner occupied. And so someone will say that and say, oh, well, then I can do whatever I want to do. Or there are certain exceptions, like when we'll talk about coming to the lead paint laws, where 2-family owner occupied properties, although it is a 2-family owner occupied property, other laws do not include that exemption. So it's the safest thing I could say to anybody for advice is don't worry about these things. Don't try to use them as excuses or accept them as reasons for not being eligible for an apartment, because there are a few exceptions, but they're less important and actually perhaps less likely to apply than most people may think or want to think they are. Yeah.
Yeah,
Exactly.
so there are certain statutes and certain provisions that have no exemption, rather. So there is no exemption to racial and national origin discrimination. In Massachusetts, the receipt of public assistance, there's no exemption for any small landlords. And then also for the lead paint, as John had said, that's another one. And then advertisements, that's a big one that we see on the federal level. Like we talked about, like the no Section 8 at this place, like for an ad on Craigslist or wherever, there are no exemptions that will protect you from liability for that.
Mm-hmm. Yeah, here's a big one.
Yeah. So there are 2 theories of liability for discrimination that we talk about a lot. One being disparate treatment, and you think of this as the very obvious, generally feels intentional conduct that comes to mind when we talk about discrimination that's motivated by discriminatory intent. And this is like that unlawful housing discrimination.
And that one really kind of makes, in quotes, makes sense. I mean, people at least get that. Even the people who are trying to get around it, they know that it's obvious that it's wrong. This takes a little bit more thought.
Yeah, absolutely. Like disparate impacts is a little bit more nuanced. It's policies and practices that on their face seem neutral, but have a discriminatory impact. Like we talked about a little bit before, making 3 times the rent, having credit scores above a certain threshold, things like that. So now we're going to talk about the common discrimination that we see, starting with race and national origin discrimination. This has been a historically and systematic issue in our country. John talked a little bit already about redlining, which is the bank not approving mortgages in a historically Black or Hispanic neighborhood. Then you have reverse redlining, which is targeting Black and Hispanic neighborhoods for unfair higher interest loans, predatory loans, things like that. And then citing affordable housing developments in lower income Black and Hispanic neighborhoods, as well as environmental justice issues, placing environmental nuisances like factories and other things like that in low income and historically Black neighborhoods. John, want to cover anything else?
Yeah, I mean, I think we're going to get to some of this again a little bit, but I mean, I remember really once being at a workshop where this was a national workshop, and they had a test case of where someone had on the surface put in a lot of affordable housing in an area where there was perhaps a need for housing, and an area which, in quotes, was in need of renewal, I think was one of the terms that was used. And in fact, what it also was doing was also, if you actually look at the demographics, was essentially helping to add and encourage segregation. And in fact, if you will, really take people apart from each other, and in the process was actually interfering with a historic neighborhood, and involved tearing down a couple of neighborhood businesses that had been important for the neighborhood. Basically had a very negative effect on the neighborhood. So this is something that was really well intentioned, but its effect was really very much of a problem. Environmental justice, again, strangely enough, a lot of times if you're looking for a siting for a particular new factory or something that might be polluting or might be, in quotes, less desirable, guess which neighborhood it gets added to. Again, we're going to hit this a little bit more, but it's worth coming back to again, that if I'm an 18-year-old kid walking down the street, or a 16-year-old kid walking down the street with some weed in my pocket, and I get stopped by the police, and the way I'm going to be treated is going to be very much different from the way that a Black John Fisher might be treated. And I'm not even talking about some of the horror stories that we see on the news, but just essentially the fact that someone is much more likely to end up with a record. And actually, an interesting statistic is that people who have among males, particularly males of color with criminal histories, who are perhaps one of the most targeted groups on that, actually tend to have incredibly good records as tenants. They make wonderful tenants, but if you look at the statistics, but it's so difficult for them to even be considered. So all of these differences, we'll get into this more, but the disparate impact effect, and again, just the threats, and even for that matter, the landlord who allows a situation in which somebody is targeted or made uncomfortable. A landlord has an affirmative duty to protect their tenants against this sort of thing too. So
yeah, absolutely.
So important.
Yeah, so the neighbors or landlords, another issue we see along these lines, neighbors or landlords threatening to call the police on undocumented folks if they report bad conditions or something going on in their apartment. That's another threat or harassment that we see based on race and national origin.
And again, I realize that some of you watching this may be in states where there's more of a policy of harassing people who are not fully legal immigrants here. But again, bear in mind that this is national origin is a form of discrimination for sure. Oh, again, just carrying this forward.
Yeah, so we covered some of this re-entry and criminal records. Having a criminal record can be a real bar to housing. It can be very problematic for public housing, but just for private housing as well. Almost all landlords do a background check. HUD has said that while having a criminal record is itself not a protected class, if the policy is affecting criminal record holders disproportionately impact Black or Hispanic folks, then the policies can have are found to have a discriminatory impact. So it can be race or national origin discrimination. You can go to the next one.
And this is some ways it gets coming back on some of the things we mentioned already.
So in the intentionally treating people with similar criminal backgrounds differently, what this looks like and how this plays out for some of our practitioners is a client will be denied public housing because of their criminal record, and they're afforded the opportunity to appeal. And that decision can be reversed if they show mitigating circumstances. So things like, I was young when I committed this crime, I haven't been arrested since, I'm employed, I have good references, you should really consider me a wonderful tenant and please reverse your decision. We've had instances where some housing providers presented with the same information for a prospective white tenant and a prospective Black tenant, will reverse their decision for the prospective white tenant and not for the prospective Black tenant.
One of the problems I think you see here too is I do housing appeals for my own agency. I also have done them for some other agencies as well. Is that sometimes you really have to, this is something we don't have time to go into here, but depending upon, again, the state, the subsidy program, and a number of other things, what constitutes an appeal always should be really that, where someone's case is looked at and really looked at fairly. But the procedures very often have much more protections for the tenant in them than most people doing the appeal realize. As a matter of fact, with Section 8 there, if you look into the Code of Federal Regulations, you will see that there's specific language which talks about mitigating factors, which requires you to take some of these considerations into consideration when making that decision. And sometimes that appeal process is short-circuited or overlooked, or the person who made the original determination just looks at it and says, yeah, I think that was right. Or, whatever. Yeah, I think my buddy down the hall is a nice person, so I'm not going to disagree with them. And that's the basis for these decisions. So this is stuff that too often goes unchallenged. And I think it's very important to challenge it. About 4 years ago, I did a workshop on this at the Fair Housing Civil Rights Conference. And I think maybe we'll be in the not too distant future doing one again that really talks about this, because this is an area where I think a lot of people miss what their rights are.
Okay, so in Massachusetts, not every state will call your criminal record the same thing, but in Massachusetts, it's called a CORI. That's the acronym that we use. It's the state's record of a person's criminal history, including arrests filed in court. So it's not only convictions. So it really is fairly complete. And because it's such a barrier for folks, the best way to help clients who are prospective tenants doing housing search is by making sure they take advantage of their ability to, 1, review their record and correct it for mistakes, and 2, take advantage of, in Massachusetts, we have a pretty good sealing law. You get to seal your criminal record much earlier than in other states. And so taking advantage of this law and making sure that folks are sealing their criminal record when they're eligible for it really can open up their housing possibilities.
And again, this is one of these ones where people really, unfortunately, even in Massachusetts, they really need to take positive action to make sure to get their rights. This doesn't happen automatically. So that and again, this is really when we talk about 7 years or 3 years, this is after whatever the case is resolved, whatever that might be. So whether that's you serve time and then, or you were on parole afterwards, or was the case dismissed, whatever it may be, so that it's really important to look into wherever you are, look into what those rights are, and be prepared to deal with them.
All right. So language access can be for folks who are limited English proficient. Not having appropriate language access can be national origin discrimination, and it can provide a significant barrier for people to obtain housing as well as to maintain their housing. I have had clients call who didn't know that they were being evicted or terminated, or their subsidy was being terminated, because they did not understand the notice that they received because it was not in the language that they read or speak. Federally funded agencies are required to be language accessible. This is so housing authorities, landlords that receive federal funds, have to make sure that they are language accessible.
And again, it depends upon your, on your state, on a number of factors, but very often the real need for having if you will, a language access plan in other words, it's part of really part of who you are for. If you're getting in maybe federal funding or state funding, there should be certain things when somebody walks in. It depends upon, again, how common your language is. If someone is walking in and perhaps speaking Quechua, that it isn't assumed that the agency will have a fluent Quechua speaker, but nonetheless, that person should be able to really make their get through their day. I mean, the analogy I sometimes use, again, we've done a workshop on this in the past in much more detail. Here, maybe we will again sometime. But think of what it would feel like for those of you, if you've ever gone into something like the motor vehicle department and found everyone was speaking Klingon. And as we all, those of us who may watch Star Trek know, Klingons are not a friendly people. And it's a little bit scary. And what is that? What does that feel like? How do we have people have access to things? Very important thing to take into consideration.
Yeah, a lot of things we see in language access plans include these I Speak cards. I'm sure that you've seen them. They're generally these like 3 or 4 pages, and it says like, well, the one I know how to read says, I speak English, and you check the box, and they have that in a number of different languages, and that provides, the staff at these agencies the ability to then find the right interpreter, right? And something I think that's extremely important is that children should not be asked to interpret for their parents. Again, we have these like heartbreaking situations where a notice is dropped off at a client's house and the parents can't read it. And it's like the 10-year-old who's finding out first that the family's being evicted because that's who can read English in their home. And it's just unacceptable.
Yeah. And again, hearings. And again, also the other thing that's really people need to be careful of, because if you speak, you may speak a language well enough to be able to do the common hello, how are you, thank you, may I have a pen to fill this out kind of questions. But some of these things are rather dense legal documents that probably Michaelin would have to look at 3 times before she is sure exactly what it's saying. And certainly when, when you're not fluent in that, I sometimes tell a story of once when I was, I do some international consulting around some other issues. And I once was showing off the little Russian I had by trying to be friendly with an immigration agent at the St. Petersburg airport, and almost got myself led away by, I don't know, the FSB or somebody. While I, thought what I thought I was saying was exactly what I did not mean to be saying. And you can get yourself into considerable trouble. So, lead paint and family status.
All right, when we talk about family, we're talking about the protected family discrimination is families with children. And these are the 3 ways that usually comes up. We can go to the next slide.
Mhm.
Yes. Okay. So there's a requirement that landlords remediate lead paint if there's a child under 6 in the household. This is the Massachusetts lead paint law. Other states have very similar laws, and this can be a consideration in other states as well.
Also, HUD has regulations too in terms of any HUD-based housing that are also similar.
Absolutely. And so this does, like we had talked about how there were exemptions for small landlords, there's not an exemption in this law. There's a lot of funding, tax credits, grants, and loans for landlords to do lead remediation. So it should not be a bar for most landlords.
And by the way, this is one of these, there's some types of discrimination that are very obvious, and some that tend, unfortunately, to be very subtle. And this is the old, I really tell everybody here, especially if you're working with people around these issues, it's the old duck issue. If it walks like a duck and quacks like a duck, it may well be a duck. At least it's worth questioning it and encouraging people to question it, because it isn't just someone might be very sophisticated. They don't want to, and again, I have some sympathy for some smaller landlords. It's very scary because the cost of de-leading is high, and they're really the support that they get in Massachusetts hasn't really been changed since 1978, so that it really does need to be brought up. That's one of the things that's pending in the legislature now, is to try to adjust that so it doesn't put an unfair advantage or disadvantage on retired people who may have a 2-family home or something like that. But the basic idea is that people won't simply come out and say, oh, you've got a child under 6, I won't rent to you, or anything of that nature. It's just conveniently somehow you get overlooked, so that this is something to always be on the lookout for.
Another way we see family status discrimination is through noise issues. Someone calls and inquires about an apartment and says that they have children, and they're denied because, oh, kids are too messy or too noisy, things like that. Or evicting a family for noise complaints where other tenants are not evicted for their noise complaints.
Yeah, again, kind of the very fact that small human beings run up and down the hall, babies cry sometimes, that kind of thing. And again, people who might put up with whatever music being played too loud, will go after the children for whatever reason. Yeah, so that this again these are the sort of this is the walking like a duck and quacking like a duck. It isn't. It's what's the real bottom cause of this thing?
This one is, yeah, this
Yeah.
one's interesting. It's almost, I think a lot of times managing agents or real estate agents will use this. Occupancy standards. That's not zoned for that many people, and like the
Mhm.
occupancy standards are very small, so it's very often not the case that a unit would actually not be big enough for a family.
Yeah, and this is something I sometimes will even see. Again, this is a Massachusetts statute. I think it's probably worth checking because most states will usually have some sort of occupancy statute buried in their housing laws somewhere, so that it is, people arbitrarily say, oh, well, I don't want to rent to large families, or I don't want to rent to large households, because, even though there's plenty of room for them, I've seen people with, 4-bedroom houses say, I don't want to rent to more than 3 people, because the assumption is there's more wear and tear on the apartment, which is not necessarily the case, but nonetheless, it's there. And again, Massachusetts, it really is, if you talk about floor space, actually, it's the living area, which doesn't include closets, hallways, and a whole bunch of other stuff, bathrooms, cooking areas, and so forth. 150 square feet is 15 by 10. That's a pretty small room. It's not a huge one anyway. And so that for one person living there has to be at least 150 square feet, 2 people, 250, and so forth. And if you're going to use something for sleeping purposes, 70 square feet is 7 by 10. That's about a bed and perhaps a chair and not much else. So again, otherwise it's multiples of 50 square feet per person who's staying there. So that unless, when you run into that, and there may also be even some other, in terms of what's being used as a sleeping space may not necessarily be what the landlord considers to be a sleeping space. So again, this is something, beware of the arbitrary use of this kind of thing. Okay, and Section 8, which we've started to talk about.
All right, it is in Massachusetts, it is illegal to refuse to rent to someone because they received Section 8. It is illegal to make advertisements that say Section 8 don't apply. It is illegal to say I won't take Wayfinders Section 8. It's a tougher case, but it's still illegal. And then it's also illegal to refuse someone because of their source of income. So if you're you get SSI, SSDI, we've had landlords say you have to have 3 times the rent and it has to be from employment wages. That's illegal discrimination as well.
Yeah, and by the way, here too, where this comes into, I see a lot of it. Sometimes large landlords, chains, which own properties in many states, they have sets of rules which are essentially made in one state, often the state in which they're registered, which is probably one with the least possible legal regulation anyway, because that's why they picked it to register in. But in any event, they will have these rules, which then the person who's a building manager, and again, building managers are not necessarily, although there is in fact, certifications and so forth that are provided. They generally aren't under the state law. They're generally just accreditation through various trainings. In some cases, someone is maybe a building manager with absolutely no training other than the fact that we're handed a set of rules. And they may, in whatever they feel good conscience, sometimes it makes it easier to tell this is discrimination because they'll come out and say it. But in any event, in good conscience, they will say, no, you can't do this, or no, you have to have that 1/3 rule, or that kind of thing. And in fact, again, know your state's laws here, because it may not be worded the way it is in Massachusetts. As I say, Connecticut gets essentially the same effect by talking about source of income, but nonetheless, know what this is, know what's happening. And again, the other part of it is the duck effect. is sometimes it's just very subtle and very quiet. I see a lot of cases where realistically tenants looking for housing, if they have a Section 8, will sometimes simply call up and the first question they'll ask is, do you take Section 8? And very often the landlord will say no, and they'll say thank you and hang up. And effectively, they've just given, without knowing it, permission to be discriminated against. So that people really do need to know their rights and know that representation may be available.
Yeah, speaking of which, can you go to the next slide?
Yes. Speaking of which,
Yeah. So in Massachusetts, there is a program that there's a grant that all the Massachusetts fair housing agencies, including Community Legal Aid, have signed on with the aim of trying to bring cases for voucher discrimination. Voucher discrimination is extremely prevalent, even though it's protected in Massachusetts. People wait a decade for their voucher, and then they find out that they can't be used easily because of things like John just said. They'll call and say, I have a Section 8 voucher, and then the landlord says, sorry, no, and hangs up on them. Last year in Worcester alone, 30% of people who were awarded Section 8 vouchers ended up returning them because they couldn't find a place to lease up. So these fair housing agencies are looking into cases of voucher discrimination and are bringing legal action and providing advice for folks who are facing this.
okay, elders, seniors, retirement housing. Any comments, Michael?
Go ahead, John. I feel like I've been talking a lot.
Oh, okay. Well, again, I mean, obviously, age is a protected category under state law. You look and see what your state laws are. Obviously, that doesn't mean that a 6-month-old baby can make a contract or what have you. But basically, you should not be subject to discrimination based upon age. And one of the things I sometimes, the flip side of it is that you see this both ways. I've occasionally seen cases where, particularly I was once involved in a case with a trailer or actually mobile housing park, where they'll sometimes people arbitrarily said this is only for people over, I think it was 65 in this case. And there are certain housing that is identified for people that are 55 or older, 62 and older. But basically, on the one hand, you can't arbitrarily do that, or no, you can't have your grandchild move in or something of that nature. And the other way around it is the assumption that people over 45 like me are somehow incompetent, not capable of really being able to live independently. You don't necessarily want to rent to them, so that it can work both ways. And again, this is the same thing we're back to before. The criteria are: is this person really going to be a good tenant, regardless, based on who they are, what their qualifications are, and real legitimate qualifications, not preconceptions associated with who they are. And this continues to be a problem.
Absolutely. We see this. Landlords don't get to make the assessment that a person doesn't get to live independently. Landlords aren't doctors. And there are other possible solutions, like getting somebody assistance or services, not just evicting them.
Also, sometimes the way you see this in the way that particularly sometimes seniors get treated as though they're just, because of who they are, they're not taken as seriously. They're not really extended the same respect that a younger tenant might be. They're considered a pest in some ways, and sometimes a pest because they may need. They may have. We'll talk about reasonable accommodation and so forth. That may be an issue that may come up for them, but rather it's seen that this is an older person pestering me with, not with their own, whatever, their own non-issues, if you will. So it works both ways. So let's talk about disability, reasonable accommodation, and so forth. What does that mean? And again, if you look at some of the laws, they use the term handicap. Depending upon when they were written. Disability is obviously the preferable term, but in any event, that's usually the same essential definition. It's somebody who has a physical or mental impairment that substantially limits one or more activities of daily living. And that's really pretty much everything you need to do to be a living, functioning human being. Feed yourself, hold a job, eat, sleep, live, dress yourself, breathe, learn, work. If you will, if you want to talk about Maslow's hierarchy of values, all of those things really apply. But anything that impairs or substantially limits one or more of these activities of daily living. Also, people who have a history. And this is, I've had this thrown at me. Okay, I had, 2 years ago, I had a bad case of the flu. And for 24 hours, I pretty much wasn't able to get out of bed or, do pretty much anything else for myself. That's not what we're talking about. But sometimes disabilities can be in remission at a particular time, but that doesn't mean that they're not there. So that when you're talking about a history, even if I'm not immediately suffering from these things now, it's still there and still needs to be taken into consideration. And also somebody who's regarded as having such an impairment. And I think to some extent that partially goes back to, it makes a good example, HIV and AIDS is particularly, I'm old enough to remember when people were HIV positive. It was scary in a sense, I suppose. If you this all of a sudden, out of seemingly nowhere, there was a cancer that you could catch, and no one quite understood it. So that unfortunately, the victims became somehow to blame because people were afraid of them on some level, and also they were perceived as being particularly concentrated in area with groups of people who were subject to discrimination anyway, so that that being regarded as having an impairment also kind of clicks into it. So that really any of these things are when you say somebody has a disability, any of these things count as a disability, even if somebody, whatever, the HIV positive person is taking their retrovirals and is functionally perfectly normal, but there's still that thing that they have to deal with. I guess really the thing to say there is that somebody can ask for a reasonable accommodation to be made to that. And do you want to really talk a little bit about reasonable accommodations, Michael?
Sure. Yeah, reasonable accommodations are a big part of my practice. And in terms of who is covered, really my clients have to identify as a person with a disability. And, I think the spectrum is very large. I think some people associate a disability with only a physical disability and having to explain to them that you can be afforded protection for a mental disability. I think some people just don't understand that they're as protected under the law. So it's in terms of who qualifies, it's interesting working with clients and their own perception of whether or not they qualify. When we talk about who's not entitled, it is interesting, this piece about illegal use or addiction to a controlled substance. This is like someone who is actively using, maybe might not be entitled, but someone who is previously suffered from substance or is not actively using a substance may be covered. It really depends on the state and the case and the court that you're in as to whether or not those protections get extended. The other thing is if they are able to provide verification of the disability. This is only required when the disability is not apparent, and actually required is not the word. Landlords can request the verification when the disability is not readily apparent. So if someone is requesting a first floor apartment or a ramp because they use a wheelchair to get around, you don't need a doctor's note for that. That should be fairly readily apparent. And the other one, that the reasonable accommodation also needs to be related to the disability. So, it's not just like I'm someone who has a disability and this is an accommodation I want in general. It has to be like I'm going to access my housing on equal footing with someone who doesn't have a disability because of this accommodation. And then you can be turned down for it not being reasonable. And the standard for it not being reasonable, there's only a few reasons that a housing provider can say it's not reasonable. And that's financial burden, administrative burden, that they would have to fundamentally alter their program, and that the client is a direct threat to others. So no accommodation would reduce that threat or eliminate it.
Mm-hmm. Okay, so go ahead.
So what is a reasonable accommodation?
Yeah.
It's a change in rules, policies, practices so that somebody can enjoy their housing on the same footing as someone without a disability. Housing providers are required to accommodate people with disabilities. And again, as I said on the previous slide, there's only a certain number of reasons to deny them. And in Massachusetts, there's case law that says it is never too late to request a reasonable accommodation.
Yeah.
You can do it in an event, you can do it prior to your tenancy being terminated. You can do it during an eviction trial. You can do it post-trial. It's never too late to request an accommodation and have your landlord respond to it. Yeah, so modifications are, we think of as, structural changes. So grab bars, things like that, that would make it easier for you to get around and access your housing. Massachusetts has one of the most tenant-friendly laws regarding modifications in private. So in public housing, a landlord is required to make the modifications if you put in the request and show that you're disabled and it's related to your disability. But in private housing, a landlord that has more than 10 units is also required to pay for the modifications. Whereas in every other state in private housing, that cost of the modification might shift to the tenant.
I also could mention here that, and again, this is very specific, but in Massachusetts, there also is a program. There's actually a nice program that can help pay, as we mentioned before, for the cost of deletting for low and moderate income landlords and tenants. But also there's a very similar program that would help to pay for the cost of doing these kind of modifications if you have a situation for the small landlord on whom this might be something difficult to do, or it might be hard to otherwise find the funding for it. And this again really is, we talked about this already, but documentation. One of the things I notice in here is also really, again, this is within Massachusetts. The idea is that if I ask for someone to make a reasonable modification to a particular disability that I have, it's sufficient for the landlord might have the right, if it's not obvious for me, to get a letter from a knowledgeable party. That does not necessarily have to be a doctor. That's the assumption. Sometimes it has to be a medical person. It doesn't. It has to be someone who's knowledgeable on that subject, number one. And number two is that specifically, if it's particularly emotional disability, something like that, you don't necessarily, you're not supposed to, you're not even the person asking for that documentation isn't supposed to require specifically what's your DSM-5 diagnosis. John is crazy, so John needs to have such an, that's something that you just simply, John has a disability such that he needs the following reasonable modification, reasonable accommodation be made to a disability, so that you don't necessarily have to get into some very personal data in there. The other thing to really talk about here, which I think is maybe, Michael, if you want to pick on this a little bit, the interactive process and why this is important.
Sure. Just one thing about the forms. Very often landlords will try to force you to use their forms, but there is no requirement that you use their particular form or any particular form.
Right.
The other thing I also recommend that my clients never do is some of these forms provide a release so that your landlord can ask for permission to call your medical provider, which is never necessary. So never sign a release for your landlord to talk to your doctor. It's just not required under the law. Interactive process. Yeah. So for the denial of an RA, a reasonable accommodation, for a financial or administrative burden, that shouldn't end the reasonable accommodation conversation. It's then on the landlord to suggest alternatives that would provide access to the tenant. The interactive process needs to be in good faith, which means that the landlord can't just suggest the same thing over and over that the tenant had already said no to, that would not actually accommodate them. And it needs to be clear. So if they're saying it's a financial burden for me to provide you this accommodation, very often I ask for the quote for the construction or what the actual cost would be. And oftentimes at that stage, landlords will just grant the RA because it was completely pretextual that it was going to cost a lot. So, being clear and getting that information very often can lead to settling some of these things.
I think the other thing that's so important here is that last bullet, that really the whole idea is, rather than going into this, as though each, you're dug in, you're simply not going to, you need to go back to this is really, if you've ever been trained in mediation, you talk about principal bargaining. That basically, what are the real interests? What's involved here? We have a problem between the two of us, if you will, landlord and tenant. So how can we solve this? If the landlord is saying, no, I can't do what the tenant is asking for, then why? How can so how can we make this work? And really, is it reasonable as opposed to simply just being a reactive action? So that's the part. Without the interactive process, this has not been dealt with properly. This is not simply saying no. I can't afford it. I can't do it. That doesn't end the process. That doesn't resolve anything. This is, how do you solve it? And a couple of quickie examples here, or I guess just one, particularly one here. And this is kind of a Massachusetts one, and it's still, it's still, and somewhere, I do have this vision of someday one of these cases going to the Supreme Court, and particularly with the Supreme Court, I'm a little afraid of when it would go to the Supreme Court, but anyway. But essentially in Massachusetts, you have a situation where recreational marijuana is legal, and I think a number of other states now have the same sort of thing. And that's simply okay. That's simply recreational marijuana. I talked to some people who act as though, you know, Moses came down from the mountain with another stone tablet that said, "Thou shalt smoke weed," and that it's not necessarily a right in and of itself any more than if there are no smoking rules, if there's some other things into it. You know, that's to some extent it's a much more, you know, much simpler question in some ways. But in terms of also, if you are using marijuana as a you know, as a medication, and there are some very important cases where marijuana really is the best medicine. They use the term medicine for a reason. It's the best medicine for certain disabilities. And in that case, certainly if there's no federal monies involved, it's not a problem. Again, you know, if CLA ever wants to take it on, there may be, I know a lot of times some of the people running, for example, subsidized housing have very cautiously looked the other way on things, but where somebody really needs to have access to marijuana for their health and well-being versus a federal law, which we don't have time to go into, but it's very interesting history as why it's treated as a very dangerous drug on a federal level, in some ways counter to you know, to most medical research. So this is something that, again, this is seek legal advice, look at carefully. I know if there's anything, Michael, you want to say about this, but it's a good example of how we're still in new territory here.
Yeah, no, I think you covered. I think that's absolutely where we are.
Yeah. And sex discrimination. And you want to talk on this a little bit, because
Sure.
we even had a workshop on one of these concepts.
Yeah. So these are the different forms of sex discrimination in housing that we typically see. I think we can go to the next slide.
Mhm.
Talk a little bit about each of
Give
them.
me a second. Yeah, I'm just trying to. Okay.
Okay, so there are both state and federal protections for victims of domestic violence under sex discrimination law. Victims of DV cannot be evicted from their home due to conduct associated with being a victim of domestic violence. Massachusetts has even further protection, saying that victims of domestic violence have a right to break their lease early or have their locks changed. Even in private housing with 60 days notice and documentation of the DV. That documentation doesn't, sometimes landlords ask for a restraining order only. That doesn't, if you get to pick the documentation. They don't get to pick what documentation. You give them an affidavit that you are a victim is sometimes can be enough. And sometimes landlords do not require documentation of the DV and will let you out of your lease early.
And there are protections to the victim too, in terms of the privacy requirements on the part of the landlord with this too.
And then VAWA creates rights and protections for all federally funded housing, so HUD housing. And so that's going to be voucher holders, federal housing authorities that receive federal funds, all have additional protections for victims of domestic violence. So these are some of the VAWA protections. You can't be denied admission or assistance for being a victim of domestic violence. And you can't be terminated from a housing program due to domestic violence. And again, you can't be evicted from housing. And while these protections exist, I will say that these evictions are brought fairly often still, and survivors do have to assert their rights to have them dismissed. So it's not that just because these laws exist that these cases don't happen. It is something that still comes up on a pretty regular basis in our organization. So in addition to gender-based violence, there's also sexual orientation and gender identity protection. In Massachusetts, it has been law since 2012. Federally, gender discrimination was expanded to include sexual orientation and gender identity protections in 2021. Great. So there are also protections from harassment from housing providers. So this will be harassment for a number of different reasons. We often get cases of sexual harassment, so like a quid pro quo situation where a landlord, is holding something over a tenant's head in exchange for sexual favors. Obviously, we talked earlier about race-based harassment. Disability-based harassment is something that is commonly on our docket as well. And there are protections against all of these in fair housing.
And finally, let's bring you here. Let's talk about affirmatively furthering fair housing, because this is a very important concept. I mean, kind of, if I want to use an easy analogy, it makes me think a little bit of almost some of the religious concept of sins of omission versus sins of commission. And this is really talking that the people need to really think in terms of sins of, if you will, omissions. This is back in some ways to we talked about disparate impact versus direct impact, that, how do you conduct yourself such that you don't just simply not do the wrong thing, you also do the right thing. Let's see if we can talk a little bit about history. I'll just run through this, and then Michael, if you wanted to talk a little bit too. I mean, in some ways, this is an issue that's kind of been around, has been kind of shaped. The federal government has sort of come in it and dealt with it a little bit more and more as it's gone along. And really back a couple of administrations back, there was actually a pretty thoroughly thought out regulation that was there that had been really put together. And then it really, if you will, got kind of changed to something along the line of be nice and don't do anything bad. I'm not quite quoting it, but it feels very close to what the law or what the regulation actually was saying. It sort of sounded good, but didn't give much guidance. And then recently there was a version, an updated version, which was really very similar to the previous version, which had kind of gone away. And that's really where we are today. There's been comment on, I guess we're now finally coming to where the regulation is going to be applied. If Michael,
Yeah.
can we talk about that a little bit?
Yeah, so affirmatively furthering fair housing is, a HUD regulation that requires HUD funding recipients. So we're talking like housing authorities and other, HUD funding
Municipalities,
municipalities and
yeah,
others to not just not discriminate, but make a plan. Well, they don't have to make a plan, but they need to they need to analyze impediments to fair housing in their area and make a plan to overcome them. So it makes them, part of the solution a little bit more. And so it has gone through different mechanisms of enforcement, and currently advocates are excited about the possibility of this regulation becoming more permanent and getting its teeth back.
Yes.
Because in 2020, as John said, it was really just sort of comply with being nice. And so now it's been reinstated, and in 2023, it's hopefully going to be made permanent.
Yeah, and again, I think this is that case study I mentioned that at the training I was once at, for example, of where on the surface someone increased the availability of affordable housing, and they did some neighborhood renewal and planted some trees and what have you. And on, this all seems very good, and in fact looked very good, was perhaps well intentioned, but the effect it had on the neighborhood was not. And that's really the kind of thinking that this approach is really trying to have people do, and trying to really require that people who are getting government money to do these things have if you will, have an obligation to look beyond just the simple superficial sense of something. So I think this is a very, very important. And again, I credit the government for having taken the time to sort of, if you will, even try to improve, not simply go back to the earlier rule, which was, I think, a very good, very strong rule, very useful rule, very useful guidance. They've really tried to look for where it might have had some faults in it and tweak it and get a lot of public comment on it. I hope we're going to just go ahead with having to comply with it now. And it's also very confusing. Real honestly, I think that turnaround for a lot of well-meaning agencies that had just put all of these things into play were suddenly told, no, you don't need to do this. And so we will see where we go. So having said all of that, I have about 18 minutes after 3. We have about 12 minutes left. We have a whole series of, as I said, unfortunately, we've been going so fast, we haven't really had a chance to look at all of these tons of wonderful questions and comments I've seen in the chat, and I haven't even looked at the Q&As here, but real quickly, hopefully some of them we may have answered, and some of them I think are just really cases of where people are really making some good points or expanding on things. But I think real quickly at this point, let me stop the sharing and put us back. Come on, stop sharing. There we go. Put us back to where we are. I say, okay, I see Ian has his hand up. If you want to, did you have a question? We got about 12 minutes. Try and see. I'm seeing a whole lot of okay, but Ian, I see your hand is up there. Did you want to say something?
Yeah, hi. Thank you for all this information. Very applicable. I'm in Texas, but it still, I would say, applies right on point. Does fair housing protect like rent-to-own style arrangements for single-family homes?
I think the answer is going to be probably very specific to Texas, but Michael, if you, I mean, this is one of these cases where you really want to talk to somebody. Like I say, it's not so much on a federal level, I don't think, but and there are different states have different regulations there.
Fair enough. Yeah. Okay. Maybe just from a Massachusetts perspective, because I have, properties all over the country, and I'm, like you said, Massachusetts may be similar in ways, but maybe different in others. Could you give me maybe some thoughts on the Massachusetts view of rent-to-own style agreements, protections, laws?
I'm going to defer to the attorney here.
Yeah, so
No problem.
it depends on, the funding sources. It depends on the agreement of the rent to own. If you're in Massachusetts and the rent to own agreement or the property, it's going to depend on the property. And so fair housing, I would assume that most of these are larger or properties, and so fair housing laws would apply. If we're
Yeah.
talking about like single family homes, then possibly not.
Mm, okay. Which doesn't give me an excuse to violate them, but right, just good to know. Yeah.
Now,
Okay.
this is seek legal advice in the state that you have the
Yeah.
specifics in, I think is my question.
Certainly.
here. Jay,
And
you had a
maybe,
question?
yeah, thank you.
Jade, you're still muted.
Jay, okay, trying to unmute myself. As
No,
one who
you're good.
as one who left Texas for Massachusetts, so I'm glad to see that everybody is here. I have a question. I work in the public housing, I'm on the board of the public housing close by. And I have a question that it stumped me. And one, it had to do with the person, and I'm not exactly sure what it is, I have to admit, has a diagnosis with neurodivergent. And for that person, the reasonable accommodation she's had in the past was a garden out front. And I just got a notice that they came and tore it up, and they were trying to contact the person who wasn't a doctor and blah, blah, blah. So I don't know the whole thing about that, but I'm curious because I really want to know how to deal with this person. And then secondly, as I wrote, I was watching the PHNs from the Ben Stone Housing DHCD, and one had to do something with rent. They've been getting out rent notices on the 6th, and the lease says it's due on the 7th, and then technically it's not due until the end of the month, but sending them friendly notices that cause a lot of havoc. And so then I read somewhere that if you are on SSI or SSDI and you get your disbursement on the 3rd, you're already coming in at this deficit. You're already due because the ED says, well, it's due on the 1st. But do you need to apply for a reasonable accommodation? It seemed like there would be a lot of residents just so you don't get what I think non-friendly letters saying that your rent is due. And then I have a couple of them, but John, I'm going to be calling you because you're close by. So I'm going to camp out at your office. So you might as well know it's me. No harassment, but
Okay, no harassment, although I work remotely a lot now too.
I'll
I'm
find you.
off on a couple of days. So I hope you don't get rained on waiting. I think generally in terms of these, I am going to again refer to the lawyer in a moment, but I think on some of these, we don't want to get too much into specifics of a specific case here, as opposed to just some of the general concepts that are involved. And again, I can talk, and again, if we talk about some of the concepts, but again, you really do need legal advice on specific cases. Michael, do you want anything?
Sure, I would say that moving a rent day is a fairly common reasonable accommodation that we do.
Okay. Anyone else have questions here at the moment? Again, I apologize. I guess I hope these save on the recording as well, because there were a lot of really some good things. Some of them were very specific about, if you have questions about what CLA does or doesn't do, feel free to give the office. And again, we are talking about Massachusetts and the CLA's service area, which is the western part of the state, right? But there are similar organizations in both states, and that if you spend a little bit of time on the internet, you can usually find somebody local to call to get some sort of guidance there as well. And the other thing is, to some extent, while I refer you to the internet, I also really caution you, because I've seen particularly landlords get into a great deal of trouble by going on. I work with landlords as well as tenants, and I see cases where landlords get in a great deal of unintended trouble by going on the internet and downloading some form or getting some easy answer, or perish forbid. The problem with the internet is there's lots of information on it. Not all of it is good, and not all of it and even less of it is valid, perhaps. And so it's very easy to get misled by it. So again, it's best to talk to somebody in the area who knows and has expertise in that particular area. Anyone else want to quickly pop in here, raise a hand? Otherwise, I hope we've answered most of the questions for everybody. Michael, I thank you so much for doing this. Again, you want to just talk quickly about CLA and your new program and how to get a hold of you?
Sure. Community Legal Aid is the legal service provider for both Central and Western Mass. I am in Worcester County, but we have a fair housing project out west as well. So we do take fair housing cases across our service area. And you can contact us if you just Google Community Legal Aid. Our information should show up. And we not only do fair housing, but we also have a robust housing practice. And then we have benefits unit, family law unit, elder services unit, and others. So we really do a lot of different legal issues at Community Legal Aid. But John, thank you for having me. I'm so happy to be doing this presentation with you. I know you've done it for a number of years. This is my first time doing this.
Well, it's good to have you. And again, I'm John Fisher. I'm with Wayfinders. We're in the western part. We do all sorts of things housing related, or tenants, homeowners, landlords. We actually provide housing, we develop housing, we run Section 8 mass rental voucher and some other subsidy programs. And I specifically work around if people have questions about whether their fair housing or landlord tenant rights are in some ways being violated. Sometimes we're a good starting space because we can sometimes tell you who you really need to talk to represent you. We can't, I'm not an attorney. Closest I ever got is somebody gave me a t-shirt from the, University of American Samoa Law School, which you have to have watched a particular TV show that was the follow-up to Breaking Bad called Better Call Saul to appreciate the humor of that. But again, we do refer to legal aid or Mass Fair Housing Center when possible. This is all the workshops for today with the Fair Housing and Civil Rights Conference. We will be back tomorrow morning at 9 o'clock and look forward to seeing you all then for the third and final day of the conference. We hope everybody's enjoying it, and thank you, everyone. Have a good day.
Thank you for everything.
You're welcome.